So good morning to all of you. First of all, I should say sorry that I cannot speak to you in Hindi because my Hindi is not that good. So I would like to speak to you in English. And I'm extremely happy to be with you. A group like this, all the elected representatives from across the country, and working for a major program like Bharat Nirman. And I sincerely thank Rural Development Ministry, Mr. Nitish Chandra, and all other officers for giving me an opportunity to be part of this gathering. Broadly, I would like to interact with you on the following lines. Since I am Principal Secretary, Tribal Welfare, I thought I should tell you about the unique status and the constitutional guarantees given to tribals in the country, and in that respect, what exactly is happening in Andhra Pradesh, so that you will have a broad idea about what are tribal areas and what are the guarantees given to them in the Constitution, and second thing, what is happening in Andhra Pradesh and in what way you will be able to help further this cause of making these tribals also equal partners in development. State of Andhra Pradesh is covered under 5th schedule of the Constitution of India. Before that, I should tell you, Article 224 of Constitution of India talks about certain sections of the society, that is, scheduled castes, scheduled tribes, who should be given a positive approach towards their development because of the huge gap between the general population and the scheduled castes and scheduled tribes. So that's why there are two schedules, wherein one schedule talks about scheduled castes, another one talks about scheduled tribes. Since they are part of these schedules, they are called scheduled castes and scheduled tribes. Under this 5th schedule, we have tribals. Under 6th schedule, under 5th schedule, we have the tribals in the rest of the country. And under 6th schedule, we have the tribals in the northeastern states. So if we take 5th schedule states in the rest of the country, Andhra Pradesh is one of the states where tribal population is also substantial. As on date, it is something like 60 lakhs out of a population of 8 crores, 7.5 crore to 8 crores as per 2011 census. So here the 5th schedule of the Constitution empowers the governor of the state to modify state and central rules, acts, if they are in contravention with the existing conditions in the state of Andhra Pradesh. And that gives a power to governor to form this tribal advisory council to advise the government in what way tribal developmental programs or in what way the problems in the tribal areas. I request all of you to understand scheduled areas and tribals are two different things. Scheduled areas are the areas which have been declared by the Government of India through a presidential order. Presidential order Part A in 1950 and Part B 1950 again, which talks about what are the areas where these acts should be implemented, where the governor of the state can make amendments to these rules and regulations with reference to tribal areas of that particular state. Under this, fifth schedule, government, that is President of India, has declared these two schedules, that is scheduled areas part A, certain areas of Andhra Pradesh, that is East Godavari and Visakhapatnam district. And then scheduled areas in Hyderabad state, there is Telangana area under part B. Under this, governor has made certain regulations. If you see these regulations, you will understand what is the speciality and specific focus one should attach to these tribal areas. See, first and foremost thing is about the land transfer regulation. That is, all the land in the tribal areas shall not be taken away by any of the non-scheduled person, except wherein the non-scheduled person proves that he was in occupation of that land as on 1950 for a continuous position of 8 years. This is a very strong act, but we'll come to the implementation of it a little later. Next one is about the Andhra Pradesh Muttas, that is, Mutta is a land estate. Under this also, all the estates have been abolished, and there also, the tribal only gets the right over the land. If a non-tribal has to get the land, he has to prove that he was in continuous possession of 8 years. Similarly, another one, Andhra Pradesh Scheduled Areas Raitwari Settlement Act. Under this also, only tribals shall get the authority or the power to get the Raitwari pattas, but not the non-tribals. If a non-tribal has to get the award, this patta, they have to show continuously for 8 years they are in position. Another one, Andhra Pradesh Scheduled Areas Money Lenders Regulation. Unfortunately, because of the money lenders in the tribal areas, most of the tribals are indebted. That is a major problem, causing a lot of unrest from the beginning. And all the departments, especially Department of Forests, Department of Revenue, Department of Police, Department of Excise, and the money lenders, unfortunately, have given a kind of an impression to a common average tribal that a tribal cannot approach any of these people with that kind of a freedom, though all these protections, all the regulations are still existing from 1950. Another one is about debt relief regulations. Since these money lenders are playing really havoc in the tribal areas, one more act has been brought into force in 1960, that is called debt relief regulations. Under this, any tribal who pays the principal, he need not pay the interest. Second thing, wherever balance amount is little less than what he should have been paying, he need to pay only that much amount, but not the interest, whatever is the length of that particular debt. Andhra Pradesh Scheduled Tribes is another, again, in 1970, debt relief regulations. Next one is about Andhra Pradesh Scheduled Areas Minor Forest Produce, a regulation of trade. Earlier we used to call them as primitive tribal groups, but now they are being called as PVTGs, that is, particularly vulnerable tribal groups, who should be given extreme attention and who should be given the special focus, because some of these communities, like Chinchu in Andhra Pradesh, or Kolam in Andhra Pradesh, or Toti in Andhra Pradesh, similarly some 12 such groups are facing the problem of severe malnutrition. In the interest of these people, this forest produce is now under the Forest Regulation Act, Forest Rights Act. They are being given the authority to collect, transport, process in their own areas, without the hindrance of regular government departments. Though there will be general control of the produce, where Girijan Cooperative Corporation, GCC, has the authority, as a monopoly authority, to collect, process, and then distribute all over the state or anywhere in the country. But that is also subject to the Gram Sabhas of that particular habitation to decide what kind of forest produce can be collected, where it should be transported, what should be the price. But this act, that is Forest Rights Act, is still to come into effective effect. Hence, right now, GCC is organizing all this. Then we have this AP Tribes Advisory Council. For example, in the forest areas, mineral extraction is going on, all kinds of minerals, various projects are going on, like your irrigation projects or maybe power projects. So wherever you have development projects, invariably it is the tribal area. Hence, it is the tribal who is seriously affected by most of these development projects. In order to protect them from this kind of indiscriminate use of forest land, two major guidelines have been given by Government of India. One is about Tribal Advisory Council's permission or Gram Sabha's permission is essential to go ahead. But we'll come to how it is being implemented a little later. And another one is about this. In the tribal areas, Gram Sabha has to give its consent. And another major intervention in proper administration of tribal areas, we have an exclusive machinery that is called for land transfer regulation. In every district, there will be a special deputy collector who will be in charge of all the land matters relating to tribals. He will be deciding who should get the land in case a non-tribal is possessing the land of a tribal. He can evict them. Similarly, we have a system called single line administration to have a kind of a general coordination among various departments. In the tribal areas, the major problem is there is no coordination between various government departments. Ultimately, an average tribal feels little suffocated. He feels that he is more or less helpless. In order to have a kind of that protection and the feeling that government is at the doorstep of the tribal, we have introduced this single line administration in the tribal areas, wherein all the departments will be working under the general control of project officer, who will be a senior scale IAS officer. And another legal protection is 73rd Amendment, which is giving effect to PESA, that is Panchayat's extension in the scheduled areas, wherein local bodies should be given authority to decide affairs of their own area, where all the minor minerals, giving licenses for the mining leases, or controlling various educational health institutions in the tribal area is under the control of these Gram Sabhas. Broadly, this is the legal framework in Andhra Pradesh to protect the tribals in the scheduled areas. In the plain areas, in any case, we will be extending only that rule of reservation. And second thing, under 6% of earmarked funds of the local bodies, and each and every department has to spend on these tribals living in the plain areas. Now we are planning to have a kind of an effective implementation of tribal supplant, the TSP. And shortly, an act is also going to come into effect, wherein funds meant for tribals shall be spent on tribals only. If at all there is any kind of a deviation, that will be punishable. So broadly, this is what I would like to tell you about legal framework in the scheduled areas of Andhra Pradesh. If any of you have needing any doubt, having any doubts or seeking any clarifications, I would be happy to clear those doubts. Thank you.